Distinguished speakers, guests, and most of all, distinguished students. Welcome to the Cambridge Pro Bono Project annual lecture. We're particularly grateful that you came out on a night where it makes us question the laws of physics when rain can come at you horizontally. My name is Jennifer Tritchell, and this is Rebecca Brown, and together with our colleagues Ricky Lee, David, and Shuham, we are the executive directors of the Cambridge Pro Bono Project for this year. We are also grateful for the contributions of Dr. Stephanie Palmer, who is the faculty representative for the project. I'm going to pass over now to Rebecca to explain what the CPP does.
Thanks, Jen. So the Cambridge Pro Bono Project, or CPP for short, was set up in the Faculty of Law in around 2011 as a means for graduate students to conduct public interest projects for external clients. So since then, for the past 13 years, every year we've conducted a number of projects for barristers, for non-governmental organisations, for courts, and looking at matters of public interest, whether that be public law, criminal law, international law, human rights law. We have ongoing projects, so each year we get a project from the Inter-American Court of Human Rights, and students are able to get involved with these projects either as a project manager, where they oversee the entire management of a project, such as, for example, the court, and student researchers who provide the substance of these public interest questions. For each project, we produce a report, and the client often uses these for their advocacy purposes. For example, I know a couple have been submitted in Parliament as a means of contributing towards actual change. Others use them to inform their decision-making or inform sort of their understanding of particular aspects of the law they practice in. We encourage everyone to get involved with the Pro Bono Project, either through contributing if you're a student as a researcher or project manager, or if you are external or have other sort of participation as in law or in public or in NGOs. Feel free to look out for our call for proposals, which often comes around August, September each year. That we would welcome you to submit a project proposal where we can see if the CPP can contribute towards that.
And we also have social media pages. So tonight, if you'd like to engage with the discussion online, you can go to Twitter, Facebook, and LinkedIn, where we have a presence, and tag us. And in order to access those opportunities that Rebecca mentioned, following those pages will ensure that you get updated in the future, in addition to the mailing lists. Every year, we host an annual lecture where we invite distinguished speakers from practice, academia, and elsewhere to address our researchers, as well as students and staff at the University of Cambridge. Last year, we were honoured to host the Chief Justice of the Supreme Court of India, and this year, in these times of great uncertainty and conflict, we are honoured to have Professor Christine Chinkin as our guest speaker. She has had an illustrious career with staunch commitment to gender equality and other human rights, rule of law, and peace and security. For now, I shall pass over to Professor Surabhi Ranganathan, who is a professor of international law here at Cambridge, to introduce Christine. And we also give our thanks to Surabhi for chairing this important discussion today.
Modern international law is not only androcentric, but also Eurocentered in its origins. A feminist perspective, with its concern for gender as a category of analysis and its commitment to genuine equality between the sexes, could illuminate many areas of international law, for example, state responsibility, refugee law, use of force, and the humanitarian law of war, human rights, population control, and international environmental law. Chinkin, Charlesworth, and Wright, 1991. 30 years later, this optimism seems misplaced, and the international legal order emerges as an ambivalent site for the advancement of women. While some feminist concerns and language have been absorbed into the international legal order, they have been shorn of radical potential and restricted in effect. Chinkin and Charlesworth, 2022. Yep. Professor Chinkin's words are, on the one hand, a sobering reminder of the little distance traveled over a long passage of time, with the international legal order preferring to domesticate feminist ideas rather than transform itself through them. And we will hear more about that today. On the other hand, they remind us of a powerful and consistent voice, her voice, that has unflinchingly identified where the blind spots and injustices lie, and has constantly pushed at the boundaries of international law and all discourse, including critical discourse, including feminist discourse, to always make us see what more there is to be done. I imagine all of us assembled here know something of Professor Chinkin's amazing career. Emeritus Professor of International Law at the LSE, Fellow of the British Academy, Chair of the International Law Association, frequent advisor to the United Nations and the Council of Europe, winner of the American Society of International Law's Gola T. Butcher Medal, author of 7 books, and I could go on. But in introducing you today, I wanted to pay tribute to the place that your work has occupied on many a bookshelf and in our imaginations, inspiring us to join our political commitments to our disciplinary skills and teaching us that it is possible to be a part of things, a part of institutions, a part of practice, without letting go of a critical position. We are honored to have you here, Professor Chinkin. The floor is yours.
Thank you for that very generous introduction. And rather horrified that we've just said over 30 years. It seems an awfully long time to have been saying the same thing over and over again. But thank you very much for inviting me. Thank you, Jen and Rebecca. And yeah, I'm very honoured to be here and to hear about your pro bono work. Before I start the lecture, I should say that quite a bit of it is drawn from apparently the 8th book, I had no idea about that, which is coming out later this year, called Gendered Peace Through International Law. Now, this is the final output of a 4-year project that I've worked on primarily with a colleague, Dr. Louise Arimatsu. Now, when you work for 4 years with somebody, you can't remember who said what first. And it sort of, just blends into each other. So a fair amount of the wording tonight may well be Louise's rather than mine. And so I acknowledge Louise's contribution to the work. Okay. As you all know, last December saw the 75th anniversary of the Universal Declaration on Human Rights. And in that 75 years, a sort of large growth industry has grown up around human rights. So we have multiple instruments, multiple processes, multiple mechanisms, and so on. And many people will argue that women have been both the architects of much of this growth interest and growth industry, and also among the major beneficiaries of that growth industry. So that we have seen women fashioning the concept of women's rights as human rights, using human rights as a tool for their empowerment and gender equality, and in the process, transforming human rights law. So what I'm going to do this evening is look briefly at the evolution of women's human rights and the interaction between women's rights and peace, including the most recent manifestation of that in the Security Council's Women, Peace and Security agenda. Reflect briefly on whether this growth industry, all of these instruments, processes, etc., have in fact enhanced women's agency. And then to ask what we can do as academics and lawyers to further progress gender equality and the cause of peace, seeing the two as interacting. Now, I should say at the outset that this is not a nice, straightforward, easy, progressive narrative. It's rather complex, it's very messy, and thinking about it is like women's lives. They're complex and messy. And I think also there's a very great danger of oversimplification at all times. So I just warn about that. The UN story on human rights commences in 1945 with the prohibition of discrimination, including on the grounds of sex, in the Charter, the creation of the Commission on Human Rights. Or perhaps we might just jump forward 3 years and say the real starting point is 1948 with the adoption of the Universal Declaration. But using either of those dates, 45 or 48, discounts women's long history of political activism for equality and peace. Feminist historians have revealed how from at least the mid-19th century, women organized in growing numbers, locally, nationally, regionally, across continents, and at least to some extent across class and race lines, to argue for gender equality and political participation, for workplace rights, for equal pay for equal rights. They engaged in diverse strategies, congresses, marches, parades, strikes, crusades, lobbying, etc., consistently demanding their right to political inclusion. Now, some groups brought together all of these subjects. Other groups were more single-issue focused. But for many, the issues were interconnected. Redressing structural inequalities was core to gaining social and economic gender justice, an end to violence, security, and therefore peace. Now, there are many landmarks in this story, but I'm just going to mention one in particular. 1915, in the midst of World War I, over 1,000 women from across Europe and the United States travelled to The Hague for an international congress where they adopted a whole slew of resolutions, including a resolution for a permanent international conference in which women should take part. They spelled that out. And this conference would deal with principles of justice, equity, and goodwill, and principles for a permanent peace. The Congress rejected, to quote, the assumption that women can be protected under conditions of modern warfare, and protested against the odious wrongs of which women are the victims in time of war, and especially against the horrible violations of women which attend all wars. 4 years later, at a second Congress in Zurich, they expressed their deep regret at the Versailles Peace Conference, which of course they were excluded, as they were excluded from all political participation, seeing the Versailles Peace Conference as, to quote, seriously violating the principles upon which alone a just and lasting peace can be secured. They urged a women's charter upon the peacemakers at Versailles. Now, their resolutions weren't completely ignored. Woodrow Wilson, for example, praised the resolutions adopted at The Hague as, to quote, by far the best formulation which has been put out by anybody. But, of course, they did not transform international law. And I think it's hard now to convey just how radical their position was. Their perception of international law's potential as a site for advancing women's interests differed radically from that of the male elites at the Versailles Conference. They sought the latter, saw it as regulating interstate behaviour within the framework of state sovereignty and legal positivism, leaving domestic affairs, equality, for instance, strictly outside the international realm, strictly only within domestic law. These women campaigners were seeking normative change at the international level precisely as a tool for challenging domestic resistance to their demands for social equality, disarmament, and social justice, all that they saw as necessary preconditions for peace, within as well as between states. So to them, peace and equality were inextricably entwined. You can't have one without the other. So when women worked through and with the League, but then the Charter and the UDHR at the end of World War II provided new institutional entry points. It's worth noting that it was through the insistence of the Indian delegate to the Commission on Human Rights, Hansa Mehta, who, apart from Eleanor Roosevelt, was the only woman on the Commission on Human Rights that was drafting the UDHR. She insisted that the wording in Article 1 of the Declaration, originally reading, all men are born free and equal, was changed to all human beings are born free and equal. And Article 2 also was influenced by her insistence to read, everyone is entitled to the rights and freedoms set forth in the Declaration without distinction of any kind, including, of course, distinction on the basis of sex. So universality was integrated into the text of the UDHR, but only partially. The male pronoun remains unchallenged throughout the Universal Declaration, upholding the position that women should have equal access to the rights designated in the Declaration, but without reference to the reality that those rights themselves had been crafted on the basis of men's lives, men's priorities, without taking account of women's lives and women's priorities. And women were marginalised within the United Nations. Their affairs were essentially consigned to the Commission on the Status of Women, the body that was created in 1946. So we have human rights at the Commission on Human Rights, women's issues over on the Commission on the Status of Women. And you can guess which was given, the greater priority. And of course, in the early years of both of these bodies, there were major contestations, major controversies around Cold War and colonial politics, controversies around class, race and ethnicity, religion, national liberation movements as those began coming into the international arena. CSW, Commission on the Status of Women, essentially in its early years limited its vision to attempting to redress a few areas where there was blatant discrimination. And so they drafted corrective treaties on political representation, nationality laws relating to married women, consent and minimum age for marriage. So a very limited agenda at that point. And essentially very little progress indeed for the whole first 30 years of the United Nations. Then we get a change, and the change followed the designation by the General Assembly of, first of all, 1975 as International Women's Year, followed by 1975 to 1985 as the UN Decade for Women. The decade provided spaces for women to come together in their thousands, which they did at the 3 conferences that were convened throughout the decade in 1975, 1980, and 1985. And the formal government conferences were accompanied by NGO parallel fora, and it was in these parallel fora that we really get a very strong representation of women, increasing as the decade progresses, and, as I said, spaces where women could put their priorities to the forefront. And the highlight of the decade, I think, was the 1979 adoption of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, the International Bill of Rights for Women. The momentum that was built up during the decade continued through the following decade. And so in 1995, we have the 4th World Conference on Women held at Beijing. Now, the Beijing Declaration and Platform for Action was, and I think remains, the most significant and detailed blueprint for women's advancement ever adopted in the international arena. It addresses, among other topics, the feminization of poverty, women in the media, violence against women, women's health, women and economics, a whole range of issues around women's lives. But I think also we have to recognize now, and after what you said at the beginning, this, of course, is when we wrote the original article about feminist approaches to international law. The 1990s were a period of extraordinary optimism. The end of the Cold War allowed for a series of conferences on a whole number of other issues, human rights, children, social development, the environment, etc. And through these various conferences, we get repeated recognition of the fact that women's rights are human rights, that gender-based violence against women violates human rights, incurs state responsibility to failure to investigate, prosecute, and punish such violence. And we also have an assertion of the right of all couples and individuals to decide freely the number and spacing of their children and to have the information and education to be able to do so, as the statement in the Cairo Conference of 1994. So these conferences, and in particular Beijing, were the backdrop to the Security Council Women, Peace and Security agenda, which was commenced in 2000 with the adoption of Resolution 1325. But before coming to WPS, Women, Peace and Security, I just want to make a couple of reflections which indicate that there were some clouds on the horizon, despite this apparent optimism in the 1990s. First, despite this huge amount of documentation that emerged from the decade, and then subsequently, CEDAW remains the only legally binding human rights treaty expressly addressing women's equality at the international level. All the other instruments, so the Beijing Declaration, Platform for Action, General Assembly Human Rights Council resolutions, the general comments, general recommendations from the CEDAW Committee and from the other human rights bodies, statements from various special procedures from the Human Rights Council, as it now is, all of these are in so-called soft law form. Even CEDAW has been discounted by some as somehow a bit less important than other international legal treaties. Reservations and indeterminate language make it, not quite as really legally binding. It doesn't look quite like those other human rights treaties. So it seems that at the international level, soft law is somehow deemed appropriate for women's advancement, and commitments are framed in language that can be readily discounted when other imperatives prevail. And second, the 1990s were not just a period of optimism, they were a period of triumphalism in the West following the collapse of the Soviet Union. This meant that there was little challenge to the predominant neoliberal economic model, despite the structural and societal inequalities that it maintains and furthers. Women were essentially brought into those existing structures without any challenge as to how those very economic structures were themselves undermining the advancement of women and of others who were also made vulnerable by those inequalities. But there were also some positives. I think one of the major positives was that especially following the 1985 Third World Conference on Women, which had been held in Nairobi, minority women from the global north and women from the global south were forming their own networks, drawing upon their own feminist, anti-racial and anti-colonial histories, and were challenging the presumed and self-appointed leadership by European feminists and European-descended feminists. They were bringing new critical thinking, such as the importance of intersectional analysis and decoloniality, into both the global women's movement and into international legal feminism. And feminists from North and South were coalescing at this point around the universal phenomenon of sexual and gender-based violence against women and girls. Its prevalence in armed conflict, really brought out in the 1990s by the wars in the former Yugoslavia, in Haiti, in the genocide in Rwanda, Somalia, DRC, and elsewhere, and of course in so-called peacetime. The detriment to women's enjoyment of all their human rights caused by the prevalence of sexual and gender-based violence. Tackling gender-based violence against women was recognized as a necessary precondition for women's advancement. It became a unifying strategy for intervention into various international law regimes. And of course, it also opened the way for recognizing other targets of gender-based violence, LGBTQI people, for instance, and therefore opening up new approaches to human rights generally. And so we come to the Security Council adoption of Resolution 1325 in the year 2000. This is the foundational resolution of the Women, Peace and Security Agenda, and Resolution 1325 is followed by 9 other resolutions. So we have, a pretty substantive and substantial agenda now. Now, 1325 itself, back in 2000, was unusual. It emanated from civil society, not from states. And civil society really had the objective of bringing a women's human rights and a women's peace agenda into the UN Security Council, the body with the primary responsibility under the Charter for the maintenance of international peace and security. So very briefly, what is women, peace and security? It's founded on the implicit understanding that conflict is gendered. It impacts women and men differently because of their gender, and that women as well as men should participate in decision and policy making around conflict prevention, conflict management, and conflict resolution. It emphasises that continuing sexual and gender-based violence and conflict is of itself a threat to international peace and security, making protection against and prevention of such harms central to the WPS agenda and thus essential for the maintenance of international peace and security. But the resolutions have no gender analysis, nor very much explicit commitment to women's human rights. The gender binary is assumed. The resolutions are about women and girls. There is minimal reference to male victims of sexual violence and none to those who are targeted for their rejection of the gender binary. Women are depicted primarily as victims of sexual violence and armed conflict, with the assumption of male perpetrators of that violence, but also male protectors through peacekeeping operations, thereby stereotyping both women and men. Nor is there significant recognition of women's multiple and interlocking identities, their different positioning, their standpoints, the multiple roles that they play both in conflict and post-conflict reconstruction, thereby occluding the more sophisticated feminist and gender analysis that was emerging through, as I said, in particular, the movement networks from the Global South following Nairobi. But turning more directly to the issue of peace in the women, peace and security agenda, notice it's the second word, women, peace and security. Despite the long history of women's activism for peace and the very title, as I've just said, peace is largely absent from the resolutions. Now, peace, in fact, had already been diluted at Beijing. Now, in the 3 previous conferences on women, under the mantra of equality, development, and peace, so throughout the decade, equality, development, and peace were the key mantra words. And this meant that in the document of those 3 previous conferences, peace had a whole separate chapter. We come to Beijing, and that separate chapter is lost. Peace is not one of the 12 critical areas of concern at Beijing. And in fact, it's sort of conflated into the chapter on women and armed conflict. This is an approach that is followed in the Women, Peace and Security resolutions. Now, in the one sense, it's progress. It does bring the realities of women and girls' experiences of conflict into the apex of the international system and reiterated the imperative of accountability. But it also introduced from the very outset of the agenda inherent flaws. By focusing on women as victims, it minimizes women's agency, despite lip service paid in the resolutions to the concept of empowerment. It reduces peace and security for women essentially to protection against sexual violence and armed conflict. Now, Beijing had included some rather broader language. Beijing had suggested a more holistic concept of security, human security, if you like, through, for example, disbursement of military expenditures, general and complete disarmament under strict and effective international control, peaceful dispute settlement. None of this language enters into the Women, Peace and Security agenda. Essentially, we have to remember the Security Council, major actors are the 5 permanent members, all nuclear weapon states, leading participants in the arms trade, and states that perceive security in military terms for national defense and peacekeeping operations. So the shift from equality, development, and peace through the General Assembly-sponsored world conferences and to the Women, Peace and Security of the Security Council displaced the centrality of women's rights and undercut peace. It was a compromise that was made necessary to secure the adoption of Resolution 1325, but it also lost much of the emancipatory and transformative objective of the women's social movement that centres on equality and peace. So WPS uneasily occupies dual positions. It's an agenda for feminists, but is located within the Security Council, the body for international peace and security. It's created a possibly unresolvable tension between existing international power structures and normative frameworks and the desire to eliminate or at least reduce gender inequality and include women in peacemaking and peace building. But demanding women's enhanced participation in decision-making about conflict resolution and management, in fact, does very little more than simply bring women into the existing order. And in any case, progress in this regard has been woeful, widespread lack of political will to pay more than lip service to the commitments made in the WPS resolutions. And I might just note that the resolutions are adopted under Chapter 6 of the UN Charter and are, in fact, another form of soft law, so we don't even get a hard law notion. And further problem is that WPS has allowed the Security Council essentially to co-opt women into its militarized security agenda and thereby to add some legitimacy to Security Council action. So, critiques of WPS. But of course, we're not looking just at the flaws in WPS itself. The agenda has to be seen against the vastly altered geopolitical landscape since the adoption of 1325 in 2000, and again since what is to date has become the last WPS resolution in 2019. The backlash against human rights, against women's rights, especially sexual and reproductive rights that are core to women's agency, an abusive gender ideology, hypocrisy and double standards, including from countries that traditionally present themselves as champions of human rights, and I'd include this country in that list, have all undermined the promise of universality in the UDHR. We only have to look at the reactions to the Taliban takeover in Afghanistan, the war in Ukraine, Yemen, Israel and the occupied Palestinian territories to see that the Security Council is not standing by its own commitments to WPS, and even its minimal promise of protection against and accountability for sexual and gender-based violence and inclusive participation are simply not being upheld. So, where does that leave us? Should we simply abandon the idea of seeking a security framework that puts peace at the centre and takes the concept of gender, not just of women, seriously? Should we accept that it was simply a mistake by us at that time to look to the Security Council for inclusion of the WPS agenda? And should we try and turn back to other institutions, perhaps the human rights institutions, and try to make women, peace and security central to the mandates of all human rights bodies? Or more directly, what can or should we do as lawyers and academics? Can we work within and through law, or should we discount law for the purposes of pursuing women's agency, empowerment, and peace? Well, perhaps not surprisingly, I believe we shouldn't quite give up on law, although I have my moments when I'm not so sure. But I do still believe at heart that we can continue to learn from the strategies that feminists have devised for over a century, seek opportunities to highlight gaps in the law, more broadly to argue that gender matters in international law, and thus in a legal framework for peace and security. Always to ask the question, does the law address women and women's interests? And then extend the question to ask whether the law recognises the fluidity of gender and other axes of oppression. Where the answer is negative, I think we should still continue to seek law reform. And we have had some significant successes in human rights, international criminal law over the past decades. Notably that by the late 1990s, feminist jurisprudence had secured landmark decisions in the newly established international criminal tribunals for the redress of sexual violence as war crimes, crimes against humanity, and acts of genocide. International human rights law has confirmed state responsibility for gender-based violence. Now, these changes feel minuscule, but without legally affirmed standards, there is no starting point. If crimes are not named, if there is no prohibition of gender-based violence, if state responsibility is not asserted, if reparations are not demanded, then space for progress is closed down. And experience shows us the importance of the role of civil activists and lawyers in asking these questions, in resisting the legal status quo, and thus ensuring that they enter an international agenda. I think without the activism and the work of lawyers, none of these things would even be part of an international law today. But I'll give two recent examples where feminist legal activism is currently being addressed and I think is making some difference. The first relates to the definition of gender in international criminal law. 1998, feminist activism achieved the inclusion of persecution on the grounds of gender as a crime against humanity in the Rome Statute for the International Criminal Court. This was a real breakthrough, gender as a basis for persecution. But once we have gender persecution as a crime against humanity, we have to have a definition of gender. And this nearly brought down the Rome Conference back in 1998. The compromise text that was eventually adopted was that gender in the Rome Statute was to be understood as referring to the two sexes, male and female, within the context of society. To quote, the term gender does not indicate any meaning different from the above. Okay, that was 1998. Jump forward 2 decades. The International Law Commission are now working on a new treaty on crimes against humanity. Special Rapporteur of the International Law Commission simply reproduced the Rome Statute definition of gender into his draft of the Treaty for the Crimes Against Humanity. Feminist NGOs mobilised, intervened, campaigned with like-minded states, UN Human Rights Council special procedures, arguing that this was very outmoded, that understandings of gender had moved on enormously since 1998, and in fact succeeded in having the definition removed from the draft articles as adopted by the General Assembly. So we now have a silence that's been created in the heart of the treaty, which at least allows for the coexistence of different views. But feminist campaigning went further to argue that bringing gender into the draft treaty should go beyond simply a definition, to bring a gender perspective into all other provisions of the treaty. Gender isn't just about one thing about gender. It's about the entire totality of the treaty. And in particular, what has been focused on, and in light of the situation in Afghanistan, where women are literally being erased from public life, the suggestion has been made that the crime of apartheid should be reconsidered, reformulated to include gender apartheid. And mobilisation has been pretty intensive. We've seen a very detailed brief that has been drafted through widespread consultation. There's been a presentation before the Security Council, involvement of the Human Rights Council Special Rapporteur in Afghanistan, bilateral consultations. A huge amount of energy is going into this. And in the written comments from states to the General Assembly 6th Committee a couple of months ago, 6 states specifically mentioned gender apartheid. 16 discussed the need for a gendered approach or raised other gender issues. 57% of the comments received raised gender considerations. Now, this is a very far cry from what you had in 1998, when even the mention of gender was enough to say nearly close down the conference. Okay, that's one example. The second example is the submission of legal briefs to ongoing litigation. Now, this is something I imagine you're all very familiar with in the Pro Bono Society. It's a strategy increasingly used as a form of academic or legal activism. Briefs can raise issues of gender and peace, as well as more doctrinal issues. And to illustrate very briefly, cases have been brought recently before the District Court, Central District Court in Seoul, South Korea, by the former comfort women, claiming reparation for the crimes against humanity committed against them by the Japanese military in World War II. Japan claimed state sovereignty. Not claimed state sovereignty, but state immunity stemming from that state sovereignty, as it's successfully done so in courts around the world. Now, state immunity, of course, protects states from having to answer for their activities before the national courts of another state. It maintains the power of the state to determine what is heard and adjudicated in other courts. State interest in free-flowing trade and other economic dealings has lifted immunity for commercial activities, but it's preserved for alleged human rights violations by the state and its high officials, even for violations of jus cogens. The South Korean legal team sought amicus briefs and came to me, for example. So with another colleague, we wrote a brief to the court. And what we did was draw on areas of international law where to show how gender analysis and the concept of gender crimes has been developed as part of international law, and to argue that state immunity is not a fixed doctrine, that it can change, and it should change in accordance with shifts in understanding of gender crimes and gender analysis. We argued in particular, according to state immunity, is contrary to WPS. The Security Council has recognised the importance of criminal trials in national courts and has urged states to ensure access to justice. This has to be inconsistent with calls to states to refuse to allow a case to go ahead because of state immunity. Further, the latest WPS resolutions have urged a survivor-centred approach to preventing and responding to sexual violence and conflict. Surely, again, denying access to courts is at odds with the concept of a survivor-centred approach. So we argued that the law of state immunity must be reassessed, taking into account the evolution of gender equality and gender crimes. We also argued that allowing state immunity essentially provides a shield to the masculinized activities of war. Well, in Korea, there were two decisions came out very rapidly, one in January 2021, which essentially asserted that immunity is not a static value. It does shift according to the changes in the international climate, including principles of human dignity, access to justice, and human rights. Another case that came out from another chamber of the Seoul Central District Court reasserted strongly the principle of state immunity as a sort of immutable doctrine of international law. In November of last year, the High Court in South Korea essentially went the way of saying that state immunity is not static, it can shift, that Japan was not entitled to state immunity and awarded compensation to the comfort women. Apparently, Japan is not appealing. Admittedly, this decision from the Seoul High Court is an outlier. It does not conform to a great deal of mainstream opinion around state immunity, although the court was very careful to draw on such precedents as it could find in other jurisdictions. But it shows that it can be done, and that when one court does it, well, maybe other courts can do the same thing elsewhere. But it also highlights a major dilemma for activist legal scholarship. Amicus briefs are intended to assist the court by providing it with a neutral, objective, expert analysis of a particular point of law. To what extent should or could they be used to argue for changing the law in accordance with an ideological position, in our instance, a feminist ideological position? And we would face this even more sort of head-on when Louise, my co-investigator, myself, were asked by the Campaign for Nuclear Disarmament, CND, to provide an expert opinion on the compatibility of the UK's 2021 Integrated Defence Review, in which it announced an increase in its nuclear arsenal. And we were asked about its compatibility with its obligations under the Nuclear Non-Proliferation Treaty of 1968, NPT Treaty. Well, we had no problems in considering the integrated review to be contrary to the NPT. But we did feel very conflicted about how we should actually set this out in an opinion. We felt constrained to use the language, style, and reasoning of orthodox legal opinion writing, engaging traditional sources of international law within a framework familiar to the intended audience, governments, parliamentarians, Foreign Office, experts, etc. So we drew on the Vienna Convention on the Law of Treaties, we drew on the Charter, we drew upon all the classic international law sources. But could we raise issues of sex and gender in an opinion on nuclear policy, or would that simply lose the audience and they just laugh us out of court? So what we did in the end was write a very straightforward, orthodox legal opinion. But we did allow ourselves at least to address the prohibition on discrimination on the grounds of sex and gender, citing research that shows the effects of nuclear exposure to have disproportionate effects on women and girls, and that to this end, any threat or use of nuclear weapons would violate the requirements of equality, And to this end, we cited CEDAW, Human Rights Committee, European Court of Human Rights, etc. So we submitted this opinion. We weren't happy with it at all. We felt we hadn't been true to our feminist gendered politics. And then we began saying to ourselves, well, what would a feminist analysis of nuclear policy actually have looked like? And we began sort of thinking about this. And we thought, well, one thing that feminist writings, methodologists do is look at context. So we could have contextualized the UK's integrated review in the UK's gendered, militarized, colonial and patriarchal history that made it absolutely inevitable in the 1950s that it would acquire nuclear weapons. We could have thought about its obligations under Article 2.4 of the Charter, arguing that its test sites, its nuclear test sites, that wrought untold damage on territory and the bodies of the people in those test sites, essentially amount to a use of force, contrary to Article 2.4. Why do we only think of use of force in the narrow armed conflict context? Surely this is equally a use of force. We could argue that the UK was not true to its position as a permanent member of the Security Council. We could have tried to rewrite the Martens Clause in a gendered way and a way that was more aligned to the 21st century. Well, I don't know what CND would have thought if we'd given them an opinion in this way. I think we know pretty well what the policymakers would have thought of it. And writing an orthodox opinion did mean that the government had to, in fact, answer questions in Parliament around our opinion. Now, of course, they thought we got the law wrong, but at least they did have to address those particular questions. But then this, again, raises yet another dilemma, which I would like to raise. It's something I've struggled with throughout my career as what I would call myself an academic activist. Should we remain within the mainstream? Should we seek reform where we can within the system, such as lobbying for further WPS resolutions, for instance, while knowing that any gains that we achieve are likely to be limited and fragile? Or do we simply carve out our own spaces, make spaces where we could show how international law could be revisioned? If there is a willingness to disrupt its foundations and seek ways to progress equalities and peace through alternative accounts of law, going back perhaps through history, through philosophy, look at changes over time, giving preference to the overriding importance of the fundamental principles of humanity and of equality and non-discrimination to overcome the interstate paradigm in contemporary international law. Some judges at the ICJ have done this. Think Judge Alvarez in the 50s, Weeramantry in the 90s, Trindade far more recently, but they again are outliers. And civil society efforts tend to remain discounted or simply ignored by the powerful as flights of fancy. Spaces such as people's tribunals, rewriting feminist judgment, places where such ideas can be put forward. But to conclude, and I think I've gone on too long, international law has been a tool of resistance. Its incoherence and its fragmentation can provide the instrumentality to challenge oppressive power. It is resorted to those who seek to bolster the legality of their position. Think Ukraine going to the International Court of Justice. It wants that legality asserted by the court. It seeks to assist those who are otherwise powerless. Think South Africa going to the court today, essentially to try to support the position of the Palestinian people. It doesn't seem to me that it's our place to decry the hope in law. Recourse to law can never be the only strategy. But at a time when politics in the world are so divisive, maybe this is a moment when we should try to reclaim the law, reclaim it and reimagine it, use the institutional spaces that are provided to carry out that reimagining and that revisioning that are possible. We are seeing at the moment multiple people trying to do precisely this. Think of the children who are bringing cases about the environment, trying to ensure their own future and environmental justice. It seems to me that as activist lawyers, at a time when traditional international law is being trashed before our very eyes, we have to act in resistance, use it as a tool of resistance, and support initiatives that call for racialized and gender justice and point in the direction of a law that values alternative knowledge and strives for multiplicity, puts peace at its center. We are all very privileged. We're academics, we're lawyers, we're in a place of very great privilege. So surely we should use this privilege to try to challenge the status quo, not simply to accept the law as it actually is, to challenge the binaries upon which the foundations of current international law are made: war, peace, conflict, non-conflict, human, non-human. Where's the dog? Is it still here? Man, women, conflict, post-conflict, all of those different binaries. I think we need to ask ourselves what kind of international lawyers we are if we don't challenge ourselves by trying to think outside the mainstream, seeking transformation. We are admittedly working against a very threatening backdrop. Critique is being silenced. The intellectual battles that are currently being fought are compartmentalized and siloed. Debate is narrowed and divorced from context. To resituate these polarized, angry exchanges through the prism of gender and peace may sound utopian, but maybe also it could help a bit to make people understand better just what is at stake in our planet today and offer better solutions for achieving equality and peace.